expert that is part of our team that works with the zoning process. So we actually, in the extension process, we have an ag law extension program, and that's their expertise, is to actually help farmers and with zoning. And so our Ag Log Institute was part of this.
And so as far as you know, these thermochemical reactions that you're describing, they can occur in an industrial zone, right?
It occurs wherever your system is located.
Thank you.
Anybody from the board?
Yeah, I have one more.
Yeah, of course.
And I'm going to go back over the same question I had before for Mr. Katua, but, and you were describing in the thermal treatment process, it's closed, and as opposed to composting, which Mr. Showalter was making that comparison or contrast. But there's a drying process that has to happen first.
Correct.
And so I'm going back over the same
Yep.
information. That airflow has to be discharged. It doesn't go into the system. So you may collect the dust. You probably will if you've got good equipment, and that depends on a lot of factors. But from my past experience, the ammonia content and the actual odor source is still going to be discharged to the air. Is that correct?
Yeah, and so what we've seen with these systems, and that's one, is the when you're looking at odors from ammonia, we know when we go in poultry houses, what do? We keep fans going because we want to get the ammonia out of there. So in any storage system, you're going to have ammonia. In any composting of this, we also have ammonia coming up during composting. When you dry it, you're just increasing that rate of ammonia that we're already getting. So it's not any more ammonia than would come out of composting, for example, which is a similar process but biological, but it may happen over a shorter amount of time.
And I think that it does.
Yeah.
It would happen over a short
Yeah,
period of time.
so it's not additional necessarily because you don't make ammonia, it's whatever's in the litter.
And it's coming out at a pinpoint spot. It's pretty intense. And again,
And so there are bioscrubbers and things that you can do to treat that.
yeah, which I don't expect is probably part of this process right now. Bioscrubbers are pretty expensive.
It depends. We actually have some one of the sites that I've worked with and the farmers I've helped with, we had a bioscrubber that actually just kind of went through like a compost area. And as long as you have biological activity, it was actually a pretty, it depends. It really depends on the scale of the system. Again, this is a fairly small system. And so we've actually done some compost-based bioscrubbers that are not very intensive. Yeah.
I have one question. Farmers right now, they'll use various methods to improve soil quality.
Yeah.
And so let's say they decide to take this biomass and they use it and they put it on their farms. But there was some concern about the paleo channel, about runoff. So in case it rains or during the watering process, there's a possibility that because of the use of biomass or whatever it is that the farmers can do may be able to contaminate the water in the channel. What's the impact of biomass in comparison to other methods on water quality?
Yeah, that's a really good question. So when we think about poultry litter, we apply poultry litter based on our nutrient management plan. We can apply it during the winter, and you apply it onto the surface. And when it does rain afterwards, unfortunately, we might get runoff of that poultry litter. That's why we looked at manure injection, which we don't use with poultry litter because it's not liquid. We use that with dairy and swine to get it underneath the surface, so we reduce that runoff. The biochar that we're applying, biochar is a much more drier substrate, and it actually has one of the things it's considered a best management practices because it has a high cation exchange capacity. And what that means is it basically holds onto the water pretty well and it keeps the soil structure in place. So it actually is considered a good soil amendment for holding that water and reducing the runoff. So biochar actually has that property that the poultry litter itself would not have.
This is a time when there's public comment.
If Mr. Showalter's concluded presentation of his,
I'd like to have the opportunity to make a closing argument at the end. I have one exhibit. Well, I tell you what, before I do this, Dr. Lansing has to get back across the bay. If there are no objections and there are no other questions, can we release her so that she can get on the road?
No objection. I also have to get across the bay, but I'll wait it out.
Okay.
I'm released.
Bye.
Okay, thank you very much. This is yours.
Andrew, what number are we up to?
G.
Thank you.
We'll admit G, exhibit.
Exhibit G, okay. And so I don't have a witness. It's really just some code excerpts, which I'm going to reference in my closing. I just wanted to have this admitted as an exhibit so you had it in front of you for my closing statement. But
Okay, I would suggest that if there are any public comments, that we do that now and let the three.
I don't believe anyone else has any rebuttal of testimony at this point.
Correct, I do not.
Okay, so Mr. Showalter's closed his case. The county and the interested parties have no rebuttal testimony. So at this point, there will be no additional witnesses from the parties to the case. Now would be the time to open public comment. So,
You all agree?
yes, Your Honor.
Okay. So we really don't want to hear a lot of repetition. We want you to be brief and be as specific as to your points as you can be.
I don't know if we can get the 3-minute clock up on the board, but otherwise staff can keep track of the 3 minutes.
So name, address.
May I have the board's leave to use the restroom during public comment?
Yes, sir. Name, address, and I've been sworn or affirmed.
My name is Matthew Olson. My address is 8322 Northwest Road, Salisbury. I have been sworn. First, I think Mr. Bill Turner, I think you spoke about how this matter doesn't really affect property values. And I would argue that if the public perception is that a property is zoned industrial, whether or not you guys have put a tag on it as such, the market's going to probably dictate what those property values do. So if the public believes that there's a biorefinery right next to their community, whether or not the zoning on there is agricultural or industrial, I think there could be an argument made. But like I had mentioned before, I'm a realtor. I live on West Road, like I said, with my wife and son and our assortment of farm animals. I'm not going to talk about property values. I could, but I kind of want to more talk about what I've learned over the past few years selling properties and what I've learned about best uses for homes in our neighborhood, since we're talking about highest and best use. Firstly, I've learned we all use our homes as a place of security. It's one of Pavlov's hierarchy of needs. After oxygen, water, and food is shelter. So, we take a very high priority, a high sense of importance on our place to live. Everyone needs a place to live, right? We have a good use of our home as a piggy bank. Everybody here has the opportunity to build up equity in their home, which can be tapped into to fund home improvements, pay for medical bills, or put a child through to college. A home is often the most valuable asset that we leave our children when we die. We also use our homes as a gateway to freedom. Homeowners unlock their creativity and self-expression when they buy a home. They have feelings of accomplishment, self-worth, and have stronger community ties in home ownership. As you can see here, we have great community ties in our neighborhood. Homes are also used to provide stability in our children's lives. Studies have shown that children are better behaved and have better educational outcomes if they have stable homes that their parents own. So I say all this, because we don't know for sure. I guess, there's some data that the air quality won't be affected or that the groundwater won't be contaminated. And that may be true. But even if it doesn't get affected, what does the data say about home values next to biorefineries? And I'll tell you what it says. It says nothing, because people don't build biorefineries next to homes, because biorefineries belong in an industrial area. Now, it is my understanding that the job of planning and zoning is to determine the highest and best use for a property. And the highest and best use for the properties in our neighborhood is for families, not refineries. So I thank you for acknowledging this as an industrial use and not an allowable accessory use in an A1 zoning. This does not belong in our neighborhood. Thank you.
Thanks for not clapping.
Good evening. This is Paul Shturko. I live at 28195 Atkins Road, Salisbury, Maryland, and I have been sworn. And I was listening to the testimonies and wanted to bring up a few things. One, the defendant stated that it will be burned 1 ton per day. Please refer to MDE permit that he filled out. It is 2,247 tons a year, 6.1 tons a day. He did state the large-scale facility is 3 tons per day. Sounds like he's doubling that. That's one. Second, he did state there will be no odors. And I appreciate those statements, because cyclone, we do know it can clean the air from large particles, not odor particles. And in MDE permit, the same permit, he is not using air cleaners that potentially would be using water to remove small particles as odors, and the defendant stated that there will be no odors discharged. Again, MDE permit states, and I think our attorney has that page, sulfur will be exhausted 5 pounds a day, ammonia. So I'm just bringing this up because I hear the statement to convince you all that it is not industrial facility, but then his MDE permits state completely something different. And we can get into details of the process. Another one, I appreciate the last witness, because the last witness, PhD, stated that this is not incineration. Thank you for that, because the attorney argued Zone A1 allows incineration, but their own witness stated it is not incineration. It is a process of paralysis. So right now, they're going against their own word. And the witness or the defendant says that they have enough litter at the site to keep burning. What happens after that? There are simple calculations that can be done based on his own MDE permit. 2,247 tons per year. Once he burns through that, he would have to change based on the 3 poultry houses, 35,000 square feet, based on 2-inch litter, 3-inch litter, or 4-inch litter. He would have to turn over all of this poultry every 2.2 months, 1.2 months, and 1.1. I hope there are people that understand that this is not feasible. Thank you. My time is over.
My name's Lee Richardson. I live at 35802 Old Ocean City Road, Willards, Maryland. So I made a big mistake tonight. I came here and didn't take my wife to dinner before. Big mistake. If he is going to grow chickens, he should have a letter of intent. When you buy a farm, doesn't mean you're a farmer. I'm a 6th-generation farmer. I've been growing poultry, grain, all my life, 30-plus years. I'm very well experienced. Composting, we compost dead birds, period. We don't compost our manure. We compost the dead birds to get rid of them, to break them into a form that we can spread on our fields. We can go, as he alluded to earlier about the litter situation, if we let scientists make the rules and not politicians, there wouldn't be a litter problem. But here we are. You know, we can talk about this machine. I don't care if it works or not. Composting is still the best way to get rid of my dead birds. It won't get rid of dead birds unless you're going to dry them down or compost them first, because it's got to be dry. And I don't care if it works. The only question here tonight is whether it is right for the zoning. I was around in 1997 when we made the right to farm law and a lot of that information, and I was well involved, and I've been involved ever since. In my opinion, this is not agriculture. It is not a normal practice. That's what the right to farm law protects, not new technologies or anything. If you want to do new technology, you go through the process. I mean, we say it all the time that you don't ask for permission, you do it and then ask for forgiveness. That is a farmer's way, but, you know, that's what I see here. And, you know, as a farmer, that's all I'm speaking for is Lee Richardson as a farmer. This is not agriculture, and I don't believe it is. I don't think the zoning, we've got to be good neighbors, and a lot of things have happened over the last several years with poultry, and we've not been good neighbors, and this is sure not helping. And I realize it's not the poultry companies this time, but building mega farms and doing other things has not been good to our neighbors. And it's time we start being good to our neighbors. The law is the law, and I think we're following the law. And that's the only question that has to be answered tonight. Thank you.
Hello, my name is Laura Leopre, and I live on 28161 Charter Court in Salisbury, and I have been sworn and affirmed. Okay, so Mr. Cathoria talks about the 3 poultry houses. We already touched base about how that's not really feasible to support his operation according to the environmental permit. And a big thing was that he said 3 tons a day, but on the permit, he said operate 24/7 processing 0.256 tons of wet manure an hour, which will equal 6.18 tons per day. The equipment he's using includes the propane-fired litter dryer, the cyclone machine that was discussed, the pyrolysis reactor, 2 stacks he has on the permit, a syngas-fired heat carrier, dust collection systems, packaging and processing equipment, and pelletizing machines. He is also registered under the North American Industry Classification System codes that are already registered for the business. There's 221117, which is biomass electric power generation. 324110, petroleum refinery. 562213, solid waste combustors and incinerators. And 325311, nitrogenous fertilizer manufacturer. Given the use of industrial machinery, hazardous material handling, and production of goods for sale, as well as needing supplemental manure to operate his plant, I support the Wicomico planning and zoning decision that this industrial operation is unsuitable for A1 zone neighborhood. And further, want to thank the board for acknowledging this as an industrial use, not an allowable accessory use in A1, and it does not belong in a residential neighborhood. Thank you.
My name is Timothy Cox. I live at 218181 Adkins Road, near the planned biorefinery. I'm a veteran, and I've been in combat action supporting all of my fellow Americans. I'm a disabled veteran with a partial right lung, COPD, and I'm fighting cancer. I spent 20 years in the military supporting this great country and all of its citizens. I want to take this opportunity to first thank the county zoning for acknowledging that this is an industrial use and not allowable accessory. Second, I want to ask you now to support me by upholding our zoning codes and laws that prevent this planned biorefinery from being approved in my residential area. I have enough issues trying to breathe without the issues that this biorefinery and the increased trucking will bring to my neighborhood. I want to thank all of you for being there regardless of who you are. I live with my disability because of my belief in you. I pray that I will be able to live whatever time I have left, free of any added issues with my ability to breathe brought on by a biorefinery that shouldn't be in my neighborhood. Thank you for your time.
Hello, I'm Carol Donahue. I'm here for the Wicomico Environmental Trust at 1001 Lake Street in Salisbury, and the Friends of the Nanticoke River in Nanticoke. P.O. Box 15 is our address there. We share the concerns of the
So
neighbors.
you've been sworn?
Sorry?
Did you say you've been sworn?
Oh, sorry. Yes, I have been sworn. We share the concerns of the neighbors and the Farm Bureau. We think the planning department got it exactly right. We've campaigned for sustainable processing of organic matter. We went and testified in support of the Bioenergy DevCo facility at the former Purdue location near Seaford. We support MDA's pilot project on poultry litter. This stuff is important, environmentally as well as agriculturally. But we don't think this is a referendum on the project design or even on the technology's potential environmental benefits. The zoning law of the county needs to be fairly applied for the benefit of the neighbors whom it is supposed to protect. The issue before the board tonight is solely whether the facility is an accessory use. Mr. Showalter's arguments have confused that issue without addressing it. He's spent his time trying to use a definition from the right to farm provisions to characterize as agricultural and allowable in the A1 district, or at least an accessory use, an activity that doesn't qualify as such under the zoning code. The right to farm provisions explicitly provide that they can't be interpreted to modify or abridge zoning laws. And so where the zoning code provides an answer, the right to farm provisions are irrelevant. Section 186-2 of the code. As has been noted, the Right to Farm Act provisions were enacted for completely different purposes. We don't think this is an accessory use because the biorefinery facility is not customarily incidental in this area, and we don't think it's subordinate to the principal use. The chronology suggests that the biorefinery is the principal intended use of this property. The MDE permit was obtained last June, even before the property was purchased. So we would submit that the proposed operation cannot be an accessory use to a permitted agricultural activity in an A1 district. We're concerned that if the board chooses to reverse the department's decision, it's our understanding that the board will have no authority at this point to impose conditions of any sort, conditions to limit the scale, the duration, or other aspects of what's presented as a temporary pilot. This may very well be a good project, but it doesn't belong at the proposed site or elsewhere in the A1 district. Thank you.
Thank you.
Hello, my name is Kristen Ellis. I live at 28302 Altman Court, and I have been sworn in. I'd like to right now speak about the broader impact
Sorry,
on,
did you say you were sworn?
I am sworn.
Okay.
Yes. Not just on our neighborhood, but on Wicomico County in general. I know that everyone has, or I think has, a copy of the paleo and where that runs along our county. And based on the zoning regulations and local codes, a biorefinery is not allowed for this current location, as it's an industrial, a manufacturing, and a processing operation. The Paleo Channel is an unlimited source of water for us, for both Salisbury, the city of Salisbury, and Wicomico County, and that includes Del Mar, Fruitland, and Hebron. It also includes, to name a few, Salisbury University, Warwick College, 16 elementary schools, 3 middle schools, 3 high schools, 14 nursing homes, and over 40 daycares, not to mention Tidal Health and all of its facilities. If you look at the enlarged, or I guess blown up paleo, you can see that this property is directly over the Paleo Channel. So I urge you to think about not only our neighborhood, but all of Wicomico County and all the outliners that rely on the source of water and hopefully will for years to come. Thank you for acknowledging that this is an industrial, not an allowable accessory used in an A1 zone and does not belong in our residential neighborhood.
All right, we're going to get ready to cut it off, so I'll take those two ladies and that's it.
My name is Krista Hughes. I live at 8599 Northwest Road in Salisbury, and I have been sworn. I just want to make a last comment about the Paleo Channel. Because of its vast potential as a source of potent water, protective measures in the form of use limitations, performance standards, and detailed review procedures are necessary to ensure that the channel is protected from contaminating resulting from environmentally incompatible land uses. The following use restrictions and standards have been developed to conserve and protect this vital natural resource. 1, soil remediation facilities. 2, toxic waste storage or facilities. 3, infectious waste storage or facilities directly related to the biorefinery, hazardous waste storage or facilities, any other that will include the underground storage or generation of materials that are ignitable, corrosive, reactive, toxic, hazardous, infectious, or chemical or petroleum laden. On a personal note, when choosing to buy my home there 28 years ago, one of the selling points was the location on the paleo and good water source. We stand with the county's decision to enforce the work stop order for this industrial business. Thank you for acknowledging that this is an industrial, not an allowable, accessible use in an A1 zone and does not belong in our residential neighborhood. Thank you very much.
That's one, ma'am.
I live right beside the biorefinery, 190 some feet. And
Your address then?
28061 Atkins Road, and I have been sworn in.
Okay. And your name?
My name is Julia Talent, and it's been terrible. I know he probably does have 2 feet of litter because the flies, you cannot get in or out of my house. He parks his car so that when I go in or out my back door, it's there. Already the traffic, the dump trucks and the truck with the empty cages and it's nonstop. And as they come in his lane, it shines in my bedroom window. And this is nonstop. I have no privacy. And if this was to go into effect, I wouldn't feel safe. Strangers coming and going all the time. This is only benefiting him. All the parts for the biorefinery are coming from his company. And all the money are coming from the taxpayers, from the grants. So for him, it's a win-win. For everybody else in the neighborhood, we're giving up our sanctuary of our homes, our peace and quiet. I sit 400 feet from the road, and all I guess I'll say is he has been doing something. They've issued a stop work order, but I see him taking jugs of liquid out of the house, his chicken house, for at least the last 2 or 3 days and loading them into his vehicles. I don't trust him. I don't feel safe. And I just want to thank Planning and Zoning for recognizing this as an industrial operation. Thank you.
Do you want to have us accept this whole packet or just the ones that were described by you?
The entire packet, because a lot of the other materials were touched on in the testimony that was given earlier, before we talked about entering specific exhibits in as we were doing the cross-examination.
We take as an exhibit exhibits that have not been examined by the board, and the amount of time it's going to take to do that.
Chairman, I may have a solution. I believe there are only objections to about 3 of the exhibits, so you could admit all that do not have objections, and I could narrow it down.
I don't know about that.
Ryan,
My point is, if they haven't been identified and discussed,
they did afterwards, yeah. I don't know which ones.
and you all don't know it, but we got 11 o'clock cutoff
Is there a Illuminati arranged that this could?
if we want to
So,
enforce it.
can I ask a question? Do you need to, will you be issuing a decision today?
We haven't decided yet, but it's going to be hard to do it by 11.
Whatever's the most efficient, we understand the
You've
time
already
constraints.
admitted
Thank you.
Yeah.
The ones that are important to you. I can't tell you what to do.
Yeah. Yeah, that's true. We'll let him then decide from here.
They submitted them. You can give whatever weight you'd like if you want to receive all of them. I only noted Mr. Showalter's objection to M and S. I know he's going through that now. So I don't know if his objection's still only, most of it, as I prepared, it's repetitious. There's county building permits, there's code excerpts, there's code definitions. I guess, I don't know what Mr. Showalter, if he only objects to M and S, I don't know if the applicant wants to withdraw M and S as being submitted.
We can withdraw.
You're going to have a closing argument?
Yes.
You are, obviously.
I'll be brief as well.
So at this point, Mr. Showalter has not noted an objection to A through L and N through R or T. So I believe those are being received without objection.
The only objection I made was the objection that there wasn't a witness who presented them. They were presented by a counsel who was not sworn. That, I'll renew that objection, but my objections to the individual documents were, I believe, limited to M, study demonstrating property value decline, and S.
The general objection to all of them is that they were just offered and not offered through a witness. The technical rules of evidence need not apply. The board can make that determination. Specifically, the applicant marked as for ID only but not for admission, M and S. So then what I would say, originally we marked the IBC excerpts from one of their witnesses as the initial A and B. I will, with the board's permission, renumber those U and V. A will become U, B will become V. And at that point, Mr. Chair, If you can acknowledge receiving the exhibits aforementioned, and then appellants A through F was received and admitted, and the county's A through M was received and admitted.
Appellants, the last one we had was G.
G, A through G.
Okay, so
A through G, correct.
the applicant goes first, and then the county, and then the interested citizens?
Yes. And you've received what I aforementioned as part of the record, correct?
Yes.
All right.
All right, Mr. Showalter.
Thank you, Mr. Chairman, members of the board. We appreciate your time and your patience. I know this has been a long one, so.
Goes both ways.
Understood. I first want to start and just say that this technology is not what the case is about. The case is about use. And this technology, frankly, I think is something that, we may find that people embrace and view as something that is absolutely beneficial to the state and to the agriculture community. The fears, the concerns, the questions that you heard, they're about the technology. The case is not a question about technology. The case is a question about use. And in this case, the use, which is processing poultry litter generated on site, is something that happens all over the county. We're talking about using a different technology to do it. But if this board finds that you can't use a particular technology, every agricultural activity that involves a change in technology has the same question and uncertainty. What technology is the county going to consider agriculture? I agree 100% unequivocally. Mr. Kathuria made it clear on the record that if this proposed activity processed poultry waste from another parcel, it's a different use. If a truckload of poultry litter is processed on this site for someone else, not generated on this site, we agree. Whether that's a commercial or industrial district, we haven't done that analysis, and we'll go through it if and when that time is relevant. But within the nature of the activity that's proposed, and someone suggested that you have no ability to impose limits, I would submit that the limits are imposed by the nature of the use. What we've proposed is to process poultry litter that's produced on this site. And the testimony, unequivocal by Mr. Kathuria, is 3 tons per day. If he burns through the poultry litter that is in those houses and exceeds and gets through new litter that's generated, that's the end of the activity until there's additional litter. There is no new litter coming to this site. Despite what everybody else has said, that's what we're committing to. That's what we believe is consistent with the zoning. And you can accept that as or impose that as a condition if you wish. But that's what this process does. This is an on-farm process. There was initial discussion about selling the biofuel. The biofuel that would be produced at such a small scale, there's not really a market for it. And when it's clear that the creation of a commercial product or the sale of fuel, perhaps changes the county's calculus, we don't need to sell it because frankly, we need energy to produce the heat. So if the biofuel was produced as a product at large scale, it still takes energy. In an industrial zoning district, we need energy. We might burn it, we might sell it in a future project. On this project, we can burn all of the biofuel that's produced on site as part of the process without creating a commercial product, without selling it. We still will need to have some additional propane, but the bulk of the energy will just be consumed by this internal process. If you compost chickens or poultry litter on site, the energy for that process of poultry waste is provided by what's on site. The nitrogen and carbon that is in that poultry litter drives the composting. The energy is provided. In this case, the biofuel coming out of the poultry litter can be used to heat the other poultry litter and to reduce it. And so this is a case about use. When you look at the county code, I think the use is very clear. And I think I certainly can see how the prospect of sale of fuel may have changed the analysis. And, we perhaps could have been more clear, have more communications with the county around the use before a decision was made. We did frankly try to meet, and, you know, are at this place because the decision was made and we were told appeal it if you don't like it, basically. Not that bluntly, but that was the. But the county code permits agriculture and agricultural operations. When you look at the table of uses, what it says is agricultural operations. The code has a definition of agriculture, which includes the raising of poultry, and which specifically includes the related buildings, structures, and appurtenances. Appurtenances means equipment. Buildings, structures, and equipment, or appurtenances, necessary to carry out these activities. The testimony is uncontroverted that in order to grow poultry, you generate litter, and that litter has to be processed or dealt with in some way. Suggested that somebody might landfill it. I don't think that happens. I don't think that's real, but it's not relevant because what we're here to talk about is the use. That poultry waste, poultry litter has to be processed, and it leaves the site. It can leave the site as dry litter. It can leave the site as compost. It could leave the site as ash, or it could leave the site as biochar. But producing something out of litter and having it leave the site doesn't change this into an industrial activity. That, by its nature, is part of poultry production. The testimony from the county staff was very clear that poultry house is a definition that's applied only to create a development standard. It's not a different use. It's considered part of agriculture. When you read the definition of poultry house, which the staff says is considered a permitted by right agricultural use, that is any structure, including all related buildings and appurtenances, buildings and equipment, designed and used for the growing of poultry. This includes, but again, is not limited to fans, feed bins, litter storage, manure sheds, incinerators, composters, and cold storage. Dr. Lansing testified that this activity would have less odors than composting, would be far better from an environmental perspective than incineration. If we proposed an incinerator, it could be proposed on this property, and nobody here has disputed that. We just burn it all. We could compost it out, just put it out in the air, let it get moisture, let it get rained on, let it release its ammonia, and turn it with a skid steer on a regular basis to keep it aerated. That's permitted by right. No question, not disputed.
Having fire department would be all over you.
The fire department may have their own considerations, but this is a zoning case, and this is a question about use. The use of composting or incineration is permitted by right, and nobody's disputed that. What we're proposing is a process, it's new technology, but it is a process that is cleaner than incineration. It's closed loop, so all of the gas and vapors that come out after the pyrolysis are captured, they're condensed, and that energy is recycled. And, you know, there were suggestions that somehow the poultry houses that are being renovated right now are generating intense truck traffic. There's no activity on the site that's generating truck traffic. The only testimony about truck traffic that's clear is when this process occurs, the truck traffic resulting from poultry operations on this site will be 1/3 of what it would be if you were hauling off regular litter. So the truck traffic will be reduced. But that doesn't matter. This isn't a question about property values. It's not a question about air quality. It's not a question about trucks. It's not a question about aesthetics. It's just a question of use. If this was a special exception use, you'd have those various considerations. This is a question of interpretation of the code, and this board is charged with applying the code as it's drafted. And when you do so, you have a couple of rules. And the first is that you have to give meaning and effect to the plain language of the statute. It's very clear that poultry houses are permitted by right, and they include the activities and structures and equipment for processing of manure, including incineration and composting, which is far more dramatic than this. It's clear that the definition of agriculture doesn't include subsets. It doesn't address technology. If a farmer has a new seed demonstration plot with new technology, they don't have to get approval for a different use. If people use different spacing for how they're planting something, they don't get approval for that change in technology. This is a question about use. And I would respectfully submit that when you look at the code, you look at the definitions, poultry uses are permitted by right in the agricultural district. That's what this is. And the limitations imposed by only processing litter on site and not selling biofuel, burning the biofuel in this process, inherently limit the process and make it just part of processing poultry litter like any other farmer. We're just using a different technology. For that reason, respectfully, we believe that the county's decision should be reversed.
Thank you.
Thank you.
Ms. Mitz?
Thank you. So I think Mr. Showalter's definitions, he's missing a really important one on that sheet, and that is the definition of agricultural products. Specifically in that definition, it says agricultural products are cultivated or raised plant, animal, or marine life that has been harvested. The important part is this does not include processed products, and we know that this process, for lack of a better word, is going to yield three products, and those products are going to be potentially sold and marketed off-site. So it's just not allowed as a use in this zone based on that definition alone. Now turning to the argument that it is an accessory use. I was paying attention to some of the language that was used to describe the technology. That language was that it's emerging, that these were claims about the technology, that this is just a pilot program. And I say all that to say that this particular project at this stage seems like an experiment. And that's just simply not what the definition is when we're talking about what an accessory use is. To be an accessory use, it must be customarily incidental and subordinate to the principal use. So just on that alone, they aren't able to meet the definition of customarily incidental. And I would just remind the board of what the burden was of the appellants. They clearly cannot meet that standard. So I would ask that you all uphold the decision of the zoning administrator. Thank you.
Thank you. Yes, sir.
Yes, sir. I would like to first thank the board for allowing the interested parties to be heard today. And I would like to add that the appellant has the burden of proof in this hearing. And so for any of their nuanced interpretations, they have the burden to establish that. Now, I completely agree with the county's interpretation that the fact that they're manufacturing and processing products is an easy exclusion, that they're not allowed under the, as a permitted use. And additionally, they're not an incidental use because the primary purpose is to test this technology. You heard it from them themselves, and that they're producing bio-oil and biochar, which are not agricultural products. Additionally, they're invoking the Right to Farm Act. The Right to Farm Act was never mentioned to the county until now, and it's a protection intended for actual farming purposes, not individuals who simply want to experiment with new technologies. These experiments can happen in an industrial zone. And additionally, the concerns are not about the technology. The concerns are about the location. No one wants this technology to be tested out right next to their neighborhood. This is a zoning issue, but it's also about what is the best use of these properties. And they have not established that they should have permission from the zoning board to test these technologies right next to these folks' homes. So I would respectfully ask that you affirm the decision of the county. Thank you.
Okay. Any questions, comments? I'll speak at once.
My comment would be the same one that I made previously.
Earlier?
Yeah, and it really is a recap of what the last two attorneys just mentioned. The definition excludes processed products, so we have to make that decision as to whether that's what this is, and I think it's clear as can be. Accessory use, customarily incidental, and this is not. And the other comment I made earlier was that this is a technology testing operation is how I view it. And with all the other comments that were made to substantiate that in the language that they used, that's what I think this use really is about.
Thank you, sir.
We have a very narrow criteria to decide here tonight, and you mentioned it in your opening remarks. We'd have to find that, and this is my understanding, that the planning administrator was either clearly erroneous or arbitrary or capricious, and I'm not there. I mean, I feel like his decision is amply supported, and at some point here, I would move to affirm the zoning administrator's decision.
And so
based on that.
Your feeling is that his interpretation of the code was accurate, and that's...
Yeah, and was not clearly erroneous or arbitrary or capricious.
And you're shaking your head, yes.
I think zoning got it right. I think the process is something that can have a bright future, but it needs to be in an industrial application anymore. I mean, if we take the application of this is a farming process, agricultural process, we can say then cracking soybean and making oil on the property is the same thing, and it's not. That's a manufacturing process that happens on an industrial scale. So I think the zoning department got it right. It's a heck of a learning experience for me. I wish you luck with the process. I just think you need to do it in a place that's zoned as the county has interpreted it.
Michael?
My overall comment is that when I make a decision, I have to determine actually impact, whether that impact is real or perceived. And there's been a lot of comment about impact in that residential neighborhood, but also have to consider the zoning. This is clearly, to me, not an exception to the way that is zoned. I think that what you're trying to do can be done in an industrial area, and that we should maintain the integrity of that zoning area.
I'm sorry that you didn't go through the correct procedures to get approval or denial before you came to this specific location. I think that there's a consensus. Is there a motion? We will have you prepare findings of fact if we do move to deny the request. And that's the right word now, is a denial from the applicant's request.
Or to uphold the decision of the zoning administrator. That's affirm the decision.
We already did that. That's why I'm confused as to what the specific wording is now.
The effect is that you uphold the decision of the administrator. That's what their appeal issue is. What you read earlier is that this is not an accessory use for the A1 zoning district. If that's what the consensus is, that's the ultimate finding, that the decision of the zoning administrator was affirmed.
All right. Go ahead.
Mr. Chairman, I make the motion that we affirm the zoning administrator's decision, and that that it was not an accessory use, and that the decision was not clearly erroneous, arbitrary, or capricious, and our affirmation in support of him should be upheld.
A motion, Mr. Turner.
Second.
Second, Mr. Ennis. Discussion? Seeing none, all those in favor of the motion to affirm the zoning administrator's what? Recommendation or, okay, decision, yes. Please signify by saying aye.
Aye.
Opposed? What will happen is that the board is charging council to provide findings of fact. They will present it to us hopefully at the next board meeting.
Correct. Now, we're going to have a meeting. You have a requirement to finalize your decision within 45 days. So we'll have to have an April meeting. My understanding is that
Nothing on the schedule.
there's nothing else on the schedule.
Do I have to?
So we'll have to pick a date that works for these 5 members. Additionally, Mr. Chair, can you just affirmatively close the hearing in public, close the hearing? I know you've made a preliminary finding, but
okay,
it's clear that the applicants, none of the parties can come back and present additional evidence or submit additional evidence by you closing the hearing.
Right, so this meeting is is closed.
This hearing's closed, and then you can motion to adjourn.
Did you all vote on the motion?
Pardon?
Yes, they did. They did, didn't they? The question from Mr. Meadows was whether or not the motion was voted on completely. And
I think the chairman voted.
he said.
I vote aye.
Well,
Thank you. I didn't do that. Okay, so the meeting is adjourned.
The hearing's closed.
The application is closed. So I make a statement okay now? Or you want me to adjourn it first?
You can make your statement if you'd like.
Okay, so anyway, what I'm trying to explain is that, as he's just explained, that we're going to have the resolution that was just approved by prepared findings of fact that we have to do within 45 days. After that is approved, then upon my signature and that date is when you have 30 days to appeal. Okay, now meeting's adjourned.